First Nation leaders are very unhappy with the decision made today at federal court in a 3-0 decision that allows the Trans Mountain Pipeline to continue construction. The decision has brought out comment from First Nation leaders, and without any further ado, here's the press conference. This is James with Net News Ledger reporting from Thunder Bay, Ontario.
It's very disappointing with the court and their decision here today. It's very disappointing with the years and years of work that we've been doing since time out of mind. But with working within nation to nation, it's been 10 years that all the nations up here have been working diligent and within our law, within our own Indigenous law. But we've been working with world-renowned scientists, world-renowned economists. We have done studies. We have done assessments, economic assessments, scientific studies, studies on the orcas, and those things were ignored today. Reconciliation stopped today. Right now, today. So we're standing here together in this little bit delay that we have in stopping this pipeline, because we're still trudging forward. We always said that we would do what it takes to make sure that we stop this pipeline. We have proven it. It's not in the best interest of our nations that are standing here, for Vancouver, for British Columbia, for Canada. This government is incapable of making sound decisions for our future generations. So we are and we will, even for their children, we will take those steps to make sure that Canada stays the way it is. In my short lifetime, 60% of the world's species have died. I've seen the water get polluted here when we said, when the tide went out, the table was set. Those years, those times have passed. Everything's polluted. We're standing up for our reciprocal relationship of spirit that we have to the lands and waters, and that's part of our law. And we have proven that in court, but not today. Today is a sad day. So we're here together to show that it's not a done deal. We're here together to share that this is a little bit delay in our process in stopping this. We have already filed to Supreme Court because they broke their own law and not allowing us to submit the evidence in this short window of time that they have given us. We're already going in that direction to Supreme Court because we knew it wasn't fair. But we're ready. We always said we would do what it takes. So thank you, my beautiful relations, for coming and standing in solidarity. And all the people across Canada, our allies, all the people around the world that support us and what we're doing, that want clean water, clean air, clean land. I'd like to thank all the nations, all the First Nations across Canada and the tribes in the States that stand in solidarity with us, that have come and supported us. We'd like to thank them all, and this is not over. So again, here our leadership stands here today. My beloved sister, my chief of Tsleil-Waututh Nation, proud leader of our nation. I'm going to ask her to come share some words. Hoichkasiam.
ACMACIA, I Tanishqualowin, quick knowledge, and the Sitsiama, meets up, Kritwilum, Tanatamoch, Tanohomoch, Slewatav, Homathquium, Skohomashot. Greetings to our honored guests and my dear ones. I have good feelings in my heart to see all of you today. In our language called Hakamitnum, Downriver Halkamelum, I welcomed you to the territory of Squamish, Musqueam, and Tsleil-Waututh. Happy to be here welcoming you to our territory. Today's decision is not surprising. We are certainly disappointed, but we are certainly not surprised. And we'd like you to know that this decision does not change Tsleil-Waututh's truth. This decision does not change Tsleil-Waututh law. This decision doesn't change how we all feel, what we all believe, and what we all know to be the truth. This decision doesn't change that. We have been successful in other areas. We won the first round, and then we won again in the judicial review that quashed the first Federal Court of Appeal. And now we're here. And while as disappointing as it is one step. It is one step in Tsleil-Waututh's shared journey with Squamish and with Coldwater and with the Chalkoic tribes. This is one step, and only one step. We have far longer to go in this journey. And we want you to know that. We want you to know that we are not the only ones standing here. This decision isn't going to just affect the Indigenous people of this land that we're standing on today. This is something that will impact all Indigenous nations. This is something that is important to all of us, and we are not the only ones standing here. The ones who came before us are here as well. The ones who came before us and laid down these teachings and laid down this path and this journey, the ones who aren't here on the earth any longer are still with us. And they're saying to us that our work is not done. Our work is not done. We're going to feel the disappointment today, but that isn't going to define us, and that isn't going to stop us. We're going to continue. There are a number of things in this court decision that we think aren't right. Canada and the courts are talking about the reasonable standard in law. Is the reasonable standard adequate? Is it enough to say that the consultation that Tsleil-Waututh, Coldwater, and Squamish Nation received is reasonable and adequate in law when we know that the record of evidence that was presented to the court was not examined? Canada, we ask you, the taxpayers, the general constituents of this country, of BC, of this city, is that reasonable? Is that adequate? If we're talking about reconciliation and protection of the environment, I don't think reasonable is adequate. I think that sets a low bar for reconciliation. And is not reconciliation the most important item on the Prime Minister's agenda? Did he not say reconciliation was important and the most important relationship to him was with First Nations? Well, we need to see some of that now. We need to see some of that reconciliation, and we need to see a different relationship. Tsleil-Waututh, and I'm speaking only on behalf of Tsleil-Waututh, we stand on our own Indigenous law, and when we say that this project cannot go through, we're standing on our own Indigenous law and on the path laid forward for us by our ancestors. Yes, we have an application into the Supreme Court of Canada to vary the order that was just decided in the Federal Court of Appeal, so that is still before the courts. And that's one of the reasons why we say that it's not over. Tsleil-Waututh will always exercise every legal option that we have. Haitsepka, thanking all of you.
I stand here with my colleagues from the Squamish Nation Council that were elected by our people to protect and uphold and defend the interests of the Squamish people, which includes our Indigenous rights and title to our territory. I stand here with our relatives from the Tsleil-Waututh Nation, as well as other nations and allies who share this common purpose and concern about the fate of our future and our communities as a result of the proposed expansion of the Trans Mountain Pipeline. I speak on behalf of the Squamish Nation saying that we are deeply disappointed with the court's decision today, but as stated earlier, this is yet but one step among the many tools and options that are available to us as First Nations people with constitutional rights. But further beyond that, we also have our own determination as a nation with the right to self-determination that still continues to articulate that the issue of title within our territory is unresolved, that we have never surrendered our lands, that we have never given up who we are and what our rights are to our territory, and that the Government of Canada, through its courts and through its laws and through its Prime Minister, have claimed jurisdiction over our lands, but we will continue to fight to enforce our jurisdiction within our territories, no matter what project that is, because we have an absolute obligation to protect the interests for our people, not just to today, but into the future. This project, although challenged by many different groups and by First Nations, including ours, have continued to stress the riskiness and the problems posed to our inlet that we all use and share together. But I also will send a message and a reminder to the public that this project proposed or taken over by the federal government was abandoned by a Texas-based oil company, recognizing that the future of oil and gas is not the future of our economy, and it is not the future of a viable, sustainable, healthy environment and society when we're looking down the barrel of a gun when we have 8 years left to reduce our carbon emissions based off of the internationally recognized limits in which we can raise carbon emissions globally. The scientists have spoken. We must act swiftly and boldly. And that this government continues to push oil and gas pipelines, knowing that the science is clear, that infrastructure such as an expansion of the tar sands in Alberta through an oil and gas or oil pipeline like the Trans Mountain Project is not in the best interest of this country or in our communities or our planet, when we're risking unstable climate for future generations. Australia is burning. BC was burning. Alberta was burning. And yet this government wants to double down on building more oil pipelines. That is not a future that we can invest in. And so our nation and many other nations are calling out, saying that this is unacceptable. The Squamish Nation is using the tools available to us to defend our interests. We participated in good faith in the consultations with the federal government. We articulated our issues consistently throughout the process. And yet we continue to encounter flaws. We will take this decision and carefully review it with our legal advisors as a council. We will explore our next options, and we will continue to call upon our allies and our friends and the people around the world who support First Nations, who support the human rights to self-determination and the human right to free, prior, and informed consent, to continue to support us, to continue to support our legal challenges with donations and fundraising through all of the campaigns that are helping to support our nations in this fight on behalf of all of us. And we will continue to work with all of our allies to protect those interests that are so integral to who we are and where we come from, but also the survival and the viability of our society now and into the future, and to protect those children who are not born yet, those children who are not here today to speak up for themselves, that demand upon us that we take bold action on this climate crisis. And we will continue to take that position as a Squamish Nation who has declared a climate emergency, who understands that this means that we need to be courageous and bold in our actions, and will continue to stress upon all levels of government within our territory that this is the action that we must take for ourselves and for our future generations. Again, I want to thank my council, my leadership, and my people for supporting us and taking the actions that we have taken so far. I really believe in the leadership of the past as well as the current who have had the courage to do this work on behalf of our people, on behalf of the world. So I really want to thank my leadership, my council who is standing here today, and those who could not be here. I want to thank the leaders who have taken these actions previously, and our leaders that have long passed, who fought for us to be able to stand here and to make this fight on the behalf of the future generations. So in my language, I'd say, Chin Kunwan, Banoyap. I'm really grateful to each and every one of you for this opportunity to share some words. Thank you.
ACM. Coldwater had multiple victories already, and they again stand in within their law and protecting their lands, waters, and people. And Chief Lee is the leader of the Coldwater Nation. I'm going to ask to come up and share.
Hansla, Squash, Lise Behan, Cook, Bevan, Sletku. Hello, everyone. I'm Lise Behan. I'm the chief of the Coldwater Indian Band. First of all, I'd like to say thank you to the singers for the lovely song, Cookstem. And I'd like to also thank Tsleil-Waututh and Squamish and Musqueam for allowing us to do this work in their territory, Cookstem. Today's decision from the court, we are very disappointed. However, today, the court did confirm that the route through the Coldwater Valley still has to be determined. The risks to our community drinking water still need to be studied. That work is underway. The court has confirmed Canada has ongoing duty to consult with us on these very important issues. It remains to be seen whether the Crown will discharge its obligation to meaningfully consult Coldwater on routing and protection of our water. We will continue to stand strong and do everything in our power to ensure our sole source of drinking water is protected. Climate change is real. We've seen it in the past with all the fires, the lack of water, not only here in British Columbia, but in Canada and worldwide. We need to protect water for our future generations. We need to stand here and tell you to have a voice for the animals who cannot speak, that need water to survive as well too. Water is life. Water is sacred. And for Coldwater, we will continue that fight to protect water. Cookstem.
ACM. So we have two members of the Union of BC Indian Chiefs, Secretary Treasurer Judy Wilson and Vice President Don Tom. Both have been huge supports in this work to protect what we love and stand within our law and incorporating that into all their work. So I'm going to call them both up to share.
I just wanted to honor our coastal nations here, the Tsleil-Waututh, the Musqueam, and the Squamish peoples that stand on their inherent laws and their ancestral laws of their people. And when they stand on their laws, the Union of BC Indian Chiefs will stand in solidarity with them and continue to do so for all of the nations that are land defenders, water defenders, and right defenders. Because the decision today by the provincial court is not only disregarded the Constitution 35, it disregarded international law, and most importantly, it disregarded the Indigenous laws of our people. And the UN Bill 41, the courts obviously have to catch up to that legislation. Because in that legislation, it says we have self-determination. We are recognized as Indigenous people, and we have free, prior informed consent. And we make decisions on land, territory, and resources. But the decisions that the Indigenous people are making are for all of us. It's protecting the water, the land, the orcas, the way of life all of us enjoy in Canada and BC. It's not just an Indigenous fight, it's everyone. because what you're making a decision today is going to affect the futures, as you heard from our speakers earlier. Climate change is real. Climate change crisis is happening now. And if we all don't work together, it's going to be disastrous. And the only ones we can blame is those top decision makers that are allowing this to happen. Because on the ground, there's changes to make a better way, to go a different way than we're going now. And we have to support that change. And all of the Vancouver Island, Vancouver, Lower Mainland, that's 3 to 4 million people that are saying no to Trans Mountain. They're standing with us. They're standing with those make the decisions to make the right choices. And all of the people along the pipeline route, there's many nations that can't get to the courts, but their proper title holders are saying no to the pipeline, and that's being disregarded as well. So when we stand together in solidarity, we're standing with our ancestors, we're standing with all of those people that know that the pipeline expansion is not a good choice. And we're standing with all of those people that are saying reconciliation has to be meaningful, and it has to be implemented in a good way to make a better way for all of us in the future. Reconciliation is about making better choices for everyone. That means the animals, the orcas, the salmon, the water, the plants, the animals, all living creation has a say. Because that's how our law works as Indigenous people. Everything has a say. Everything has a right to thrive. Everything has the right to enjoy a way of life. Because that's the way it was supposed to be. It wasn't supposed to be the 1% benefit at the expense of the 99% of us who have to pay daily, not just in the dollars, but through our lives, through our unsafe drinking water, through the decisions that only benefit the government and 1% that never get returned to us. So we're at the Union BC Indian Chiefs. Our Grand Chief, Stuart Phillip, can't be here today, but he relays that he is standing in solidarity for each and one of us and the nations that are taking this fight up in the courts, that will continue to take this fight to the highest level of those courts. Will continue to stand with them. Cooks Jam, and thank you.
Chief Don Tom, Sartlet First Nation, Vice President of the Union BC Indian Chiefs. My First Nation is located about 30 kilometers north of Victoria on Vancouver Island. We are also engaged in the consultation process, and today's decision is very clear that the Federal Court of Appeals is more interested in getting the $4.5 billion project through and completely disregard the Aboriginal law, the law of the Tsleil-Waututh, the law of the Squamish, the law of the Coldwater. Time will tell that this is the wrong decision. Time will tell that the federal government's disregard for the safety of the environment, of the increase in tanker traffic, is reckless. The complete disregard for the southern resident killer whales is reckless. It is very clear that this federal government only interest is getting this pipeline through, and it doesn't matter at what cost. This decision today is reckless in the sense that it clearly wants Indigenous peoples to remain as Canada's Indians, to obey the laws that they had set out a long, long time ago that just simply do not apply in today's world. When we have Aboriginal law, we have Indigenous law. And for the Court of Appeals not to consider the evidence is reckless. And time will tell through the Supreme Court of Canada that they were wrong. They are wrong in today's decision. We have First Nations have a good track record of success in the Supreme Court of Canada. I have no doubt that we will be successful as well in supporting the nations who will be proceeding with the Supreme Court of Canada, that they will be successful. because today's decision is just simply wrong. It's wrong in the sense of moving forward to be stewards of the environment. That is not Canada's priority. It's very clear that when you see the increase in tanker traffic, you will see an increase and a potential for human error, mechanical error. We've seen that in English Bay. The response, world-class response, is a joke. Today, we know that our resolve has been unchanged. Our resolve to uphold the standards of our own stewardship. Today, it's the nations that we stand here today are looking out for our interests of the environment, of our waterways, and we stand with them wholeheartedly. With today's decision, we look at the land defenders who are already out there occupying offices, and without a doubt, we will see an increase of land defenders. You will see an increase of stewardship. You will see an increase of those who have the concerns of future generations, those who have the concerns of our Indigenous law. Our resolve has remained unchanged. I cannot express today that we are disappointed with the ruling that has come out, and that we will, at the Union, continue to stand with Tsleil-Waututh, with Squamish, and Coldwater. Thank you.
There you have it. You know, we need to understand that it would be easy for any of the nations to negotiate and be partners with this, but it doesn't make sense. When we say within our law, that is the reciprocal relationship spirit that we have in land and water. That's what I was saying. But what we did is we spoke the language of the settlers here, where we worked with world-renowned scientists, world-renowned economists, and we explained that it doesn't make sense because it's inevitable of a spill. 87% chance. You can only clean up 20%. There's multiple things that we brought forward that the government did not, the courts did not look at, and the government as well. They relied on the National Energy Board and their expertise of the work that they'd done in their feeble attempts for a consultation. We don't have to look very far to remember what they did. In the very beginning, Stephen Kelly put in 20% of Kinder Morgan's application to the National Energy Board on behalf of Kinder Morgan, then was hired by the National Energy Board. The ministerial committee was an egg that they tried to unscramble. Again, and again, it was wrong. And how they conducted themselves was wrong. And we go back to our law, why we're doing what we're doing. People are dying at the Alberta tar sands, the highest concentration rate of cancer. Our elder, when we did a referendum, stood up and said, it's reason enough for us to say no when people over there are dying. How could we benefit from something like that? And then coming from the tar sands all the way to here, all the potential disasters that will happen, not just to the people, but to the fish. We're all salmon people here. It's disappearing. There's nations along the pipeline that are going to suffer. The water along the pipeline are going to suffer. The land along the pipeline is going to suffer. And right here, in what we call one of the most beautiful cities in the world, will suffer. Our studies show when a spill happens, within hours, 1 million people will get sick. 500,000 birds will die and never return. Look what happened with the spills that already happened, where we took our studies from. Exxon Valdez, almost 30 years later, the water there is still dead. That's why we have allies, north and south and east. Because down in Washington State, our allies there, they wanted to come today, the tribes, because it will affect them, but it will affect Canada, British Columbia, and even Alberta. As it was said already, there are fires there already. The aquifer, in the government's own study, said that it's going to dry up and the tundra is going to get too dry and then fires could happen. And that's exactly what happened. Their own studies say that, but they still continue with this. So here as a collective, we're saying no. We're making choices for Canada and Canada's future generations. So Heichka, to the leadership here and what you stand for with the people that you lift up, very proud moment to stand with each and every one of you, because it's not over. It's not over, so we'll take a couple questions at this time. We already are. To stay with the nation. Okay.
Thank you. The question was, do we plan to seek leave to appeal to the Supreme Court of Canada? We have an application into the Supreme Court of Canada currently. It's still before the court. And as we have said from the beginning, Tsleil-Waututh will always consider our legal options.
So the application that you have before the court was regarding the September 2019 decision?
Yes.
You have to wait for that.
Yes. Thank you.
So what are your options at this time to continue to fight the pipeline?
What's the question again?
What are your options right now to continue to fight the pipeline? How will you proceed right now?
Well, that's the thing. We do have options. I think there are holes that we saw that we just sat down just for an hour with everyone here, with our lawyers. So what we have to do is go sit down and look at those options. But you want to address anything?
Yeah, I think there is a couple important facts about this. There is the request to seek leave through the Supreme Court of Canada regarding that September 2019 decision, and that's something that Squamish and Tsleil-Waututh and other environmental groups. So there's that Supreme Court issue. There is the potential now for the nations and the litigants here to then seek leave to the Supreme Court on today's decision, and we have 60 days to do that. So I think it's important for the media to understand that there are two potential options when it comes to the Supreme Court. In addition to that, there was the decision at the BC Court of Appeal regarding the province's conditions that it can apply to the project in light of the reconsideration report. The province is currently going to be doing their own process to engage the nations and other groups around other conditions that might be applied through the province's certificate. And so I think that there are a few options legally there. In addition to that, I also do think it's important to recognize that BC has a long history of civil disobedience when it comes to environmental issues, where there have been instances in BC's histories where hundreds of people were willing to face arrest. And I think it's important for the Prime Minister and the Premier and all of those leaders that are considering their options on this, that there are a lot of people who are willing to do a lot to defend our coast and to defend our communities. And that's, I think, really integral and important to this, because as we've seen throughout history, it requires that strength of courage to stand up to those unjust laws that later on we realize that those laws were unjust in the first place. And even though public opinion polls change and go and come in this way and that way, again, we can see throughout history that public opinion polls change. That the thing that was offside 50 years ago is now onside today, and that's because people stood up for their rights, people stood up for the issues that are important to our society. And I think fighting the climate crisis is important to a lot of people, especially here in BC, and I think in other parts of the country as well. And we know that there's lots of support in other provinces. Quebec, for example, in terms of its opposition to this project.
So our lawyer, Scott Smith from Gullings, is going to add some insight as well.
Yeah, just to add some further clarity to the question. So Tsleil-Waututh, Squamish, and a number of applicants currently have applications for leave before the Supreme Court of Canada. That was in relation to the decision to grant leave and exclude a number of issues from the judicial review that led to today's decision. So that leave application is currently before a panel of the Supreme Court of Canada. So that's the first answer to your question. What you've heard from leadership today in relation to this decision It was released at 10 a.m. And leadership only had about an hour to consult with legal counsel. So I think you've heard very clearly from a number of the nations. They're going to sit down with their counsels, legal counsel, and consider all options. And from the Tsleil-Waututh perspective, you heard Chief George Wilson speak to Tsleil-Waututh considering all potential legal options to continue its staunch opposition to the pipeline.
We'll take a couple more questions.
Canada says that they fulfill their requirement when it comes to consultation, but we feel that they were fulfilled when it comes to, in regards to UNDRIP.
Scott, do you want to try again? Both of you.
With only an hour to review the decision, but based off of our understanding of what the courts have said today, I think that part of the structure of our society is that we still have the option to go to the Supreme Court to review the decision that was made by the appeals court today. And so while the appeal court has made the decision, it is not the final answer on this. That being said, I think that there are a number of instances where we are now slowly discovering that the law on these issues does not meet the minimum standards of the human rights of Indigenous peoples, and that is what the UN Declaration on the Rights of Indigenous Peoples. It was created because human rights tools that existed at the time were inadequate at addressing the individual and collective rights of Indigenous peoples. Indigenous communities and nations continue to argue for those minimum standards to be applied within all parts of our society. And it goes to the heart of why Indigenous peoples are in the situation we are in today. And it's because of the very discriminatory, very racist, very genocidal laws that have existed within Canada and around the world that have resulted in the socioeconomic conditions that Indigenous peoples face today. And our advocacy for minimum standards of human rights for Indigenous peoples has to do with the protection of Indigenous existence, Indigenous peoples, Indigenous communities. That is a continuation of those laws that have persisted for a long time. And so on the UN Declaration, it does have minimum standards about free, prior, and informed consent. That is a standard that is continuing to be implemented within law and is something that will continue to be advocated for by, I think, many First Nations.
I think people need to understand what meaningful consent would mean to the average person in this society and what it means in the court. Tsleil-Waututh was in our discussions with Canada. Tsleil-Waututh was ready and did sit at the table and engaged in discussions. We conducted our own review. We did our own studies. We did our due diligence. What concerns us is that the courts did not address the scientific issues that Tsleil-Waututh raised regarding our rights and title, including the impacts to the southern resident killer whale, the risk of oil spills, and the likelihood of the oil spills being cleaned up. And Canada scientists agreed with our scientists. So in our view, that isn't meaningful consultation.
I needed to add to that, you know, what Canada considers meaningful consultation, it wasn't meaningful at all. When the water aquifer study hasn't even started and they say they're going to bring a report back, how can they say it's meaningful consultation when a report that hasn't even started and hasn't even been completed, how can they consider that as meaningful consultation in the evidence that was given? And so I can't say that with the decision that they made today, it wasn't meaningful. Canada had their mind set already on this decision. Gukstam.
One more?
On the last day of the hearing of the Federal Court of Appeal, the Chief Justice, in closing remarks, compared what we've listened to is presiding over an acrimonious divorce. I wonder, given what we have before us now for this decision, how your nations are characterizing where that relationship stands in the government-to-government basis with Canada.
What? Yeah, I don't think we were married.
Yeah, you heard her. We weren't even married.
But we can add to that. We can add to that.
I just have a question. In the section of today's court ruling, it said that Canada's efforts at consultation were hampered by Tsleil-Waututh's conduct throughout the reinitiated consultations. They said that conduct during the reinitiated consultation process exceeded hard bargaining and interfered with Canada's efforts to consult.
Oh, I can take that one.
Okay, that's all they said though, yeah.
We can agree that that is what the court said in the decision, but what the court didn't say is really important. The court didn't point to an example of when Tsleil-Waututh wasn't participating, when Tsleil-Waututh was being, I can't recall the exact words. Tsleil-Waututh was there. We did our due diligence. We did our own studies. We did our own assessment. We know the science. And in this decision, the science wasn't even considered. The record of evidence wasn't looked at. In the last decision, when the court said the consultation needs to be redone, when we were all happy and we went back to do the redo of the NEB and the phase 3 consultation, the court actually looked at the record. Remember, they said it has to be more than just someone coming to take notes. In this decision, you will see that there is no reference to the record. They didn't say what was done, what did the consultation mean, and they said, I can't recall the exact quote about Tsleil-Waututh, but there wasn't any evidence to back up that that is the way that Tsleil-Waututh was acting, and I take exception to that, and that it isn't true. We were there. We were there every time there was a meeting. We came prepared. We had solutions waiting. They didn't even listen to our concerns. We didn't have those kinds of discussions. So if this was a divorce, I don't think that was an appropriate characterization. And as a woman, I'm offended. I think it was more like a railroad, or it wasn't an acrimonious divorce, that's for sure.
You're all available, eh?
If you found this video helpful, hit that subscribe button, hit that like button, share this video, and keep up to date on what's going on.